Please remain seated. Okay, plaintiffs, did you decide how to use your time?
Yeah, I'd like to say some words first and then,
Didn't you want Muntz to go? Was he gonna?
Muntz can wrap it up, yeah.
Okay.
I'll go first and then Christopher Muntz, who's on VGs, will wrap up.
Great.
Counsel previously had alleged some things about me. I just want to make note, I'm not on trial here, but I do want to address those things because they're very important to my character.
Well,
There is,
I'm not gonna take anything into consideration about that, but certainly make your
if I
record.
just may, there is a GoFundMe, and I haven't touched $1 of that. My wife and I did not even create that. There's an 8-person shareholder committee that has created that GoFundMe, who manages it. I haven't touched $1 of it. I've funded this entire trip, even Mr. Genis, who is hurting financially right now. I paid for his flights out here, paid for my flights out here twice now, paid for hotels and all that stuff. I know it's not part of the case. We even got some shareholders to help us with rooms to take some of the costs. I'm here. I don't want to be here. There's a father-son overnighter I'm missing tonight for my 13-year-old. There's a funeral I'm missing today for my uncle. I can prove those things. It doesn't even matter. It's not relevant. But since it was alleged that I'd be taking money for my own good, that just was insulting to me. And I'm not making a dime from that website. I'm funding this cloud services for that website. So we got that over with. I didn't know there was 68,000 shareholders. If we had information to inspect, we would have known that. That's great. But however, you would think the ones most invested would be searching all over for help. And I can prove that we have 1,450 people that have up to 50 million shares that are vested in this investment. There could be tens of thousands. Well, it would, I don't know the quick math on that. We do have some leads for attorneys. It's been a tough process, as I mentioned previously. As was mentioned, says a lot of allegations without evidence. Well, there's lots of evidence. Let me just reference one about the independent directors. In Exhibit 3.1, it says right here in black and white that Jesse Law and Brian Hart were made managers at Zash. I didn't sign that document. That was signed by Theodore Farnsworth. That's July 28, 2022, in the exhibit. I can pull reference after reference of this type of information. The bond was paid with my money. Again, irrelevant. The loans, it goes back to what Mr. Genis referred to previously. There's a consistent history of loans made to these independent parties, and in some cases the loans were forgiven. And for example, Lisa King, she founded Magnify You, and she's lent money, and then we only get a small percentage of revenue for that. We lent millions of dollars to Zash, and those loans were supposed to support the development of our asset Lomotif. Meanwhile, the Lomotif platform continues to not even receive some of the most basic things. As a software developer, I could be an expert witness on this. There's small features like commenting that you could build in a few hours. And we've spent millions of dollars in loans and we'd get no updates. With regards to the empty facilities, and I had no idea that there were threats and that they closed them because no one's notified us in this last 2 weeks, but I know that we have eyewitnesses that have not just gone in the last few days because of this case, but have gone months ago to see that these locations have been empty. And they would be glad to be witnesses in this case, as far back as December. There are a lot of people with their eyes on this case, thousands, that I personally am aware of. And I'm sure there's tens of thousands more. People have formed a group, we formed a group on LinkedIn, and there are new people every day. I got this morning over 60 emails from people. Good luck, our prayers are with you. We hope you succeed, because they want this company to succeed. If this company succeeds, we succeed. And I'll refer to Mr. Muntz. Thank you, Your Honor.
Thank you. Mr. Muntz?
Soft deal.
Your Honor, I'll be brief. I'm a pretty concise and to the point type of speaker. Really, Your Honor, our case, in my mind, comes down to really two elements: the Series A preferred shares and the board of directors. And interestingly enough, in Ms. Stein's rebuttal, she never even addressed the Series A preferred shares. And in my mind, Your Honor, this is a critical piece of why we're requesting the TRO in the first place. In my opinion, and in reviewing the law, NRS 78.380, which is the reference they used, which it cites issuance. Actually, I'll read it. It's amendment of articles before issuance of voting stock. The company knew they already had voting stock. They amended the articles anyways to these preferred shares without shareholder approval. They violated the law. I understand that, I know Ms. Stein addressed like a derivative lawsuit versus filing as individuals. I don't know anything about that. All I know is that I'm pointing out a point in time where they violated the law to amend articles of incorporation to potentially rig their vote so they could pass proposals that are self-interested and not to the benefit of shareholders. Your Honor, the harm of this? So they're set to vote in less than a week, or they're set to have the shareholder meeting in less than a week. If these are approved, this will approve dilution up to 750 million shares, which triples our float, or triples our shares outstanding. It gives Mr. Farnsworth 144 million shares that he doesn't deserve. It incorporates toxic financing with financiers that have contributed to our downfall and the issue. There is serious harm to shareholders. They're violating the law by amending these articles of incorporation. She never addressed it. In my mind, Your Honor, this is why the TRO must be approved, because if not, the shareholders of the company are going to suffer serious harm. In addition, Your Honor, I wanted to address a point that Ms. Stein raised as well with regards to a hostile takeover. She's right. A hostile takeover did happen. The hostile takeover was Mr. Farnsworth and his team and their takeover of the board of directors. Your Honor, in December of 2020, Zash executed a plan of merger with Vinco Ventures to merge the two companies. As part of that plan of merger, Zash was able to place two of their own board of directors into the company. Mr. Vanderbilt, who is the chairman of the board, and Lisa King, who was also the CEO at the time, she was also a board member, as well as three independent Vinco selected board members. In July and August of 2022, John Colucci, who was a board member at the time, filed a press release saying that Mr. Farnsworth was attempting a hostile takeover and that the company squashed it. Well, as you know, Your Honor, this went through litigation, and it was settled in September of 2022. The settlement resulted in the resignation of the three independent board of directors, who was placed two of the board of directors, Mr. Law and Mr. Hart, who had prior affiliation with Mr. Farnsworth, serving as prior managers for Zash. So they replaced two of the independent positions with two TET affiliates working, in my opinion, allegedly on his behalf. So as you can see, if you have 4/5 of the board, it doesn't matter if Mr. Levitchin is independent or not. I have no idea what his prior affiliation was, if there was any with Mr. Farnsworth or any of the board members. But if you have 4/5 of the board, you can execute pretty much anything you want to do. And that goes back to the Articles of Incorporation. It requires vote.
Can you go back?
If Mr. Farnsworth
Whoa, Mr. Muntz, it requires a vote. Go back. You broke up.
I'm sorry. The Articles of Incorporation, the citation that I referenced, 78.380, requires 2/3 vote of the board of directors to actually execute the amendment. And so if they control 2/3 of the board with no safeguards or roadblocks or barriers or conflicting views, then they can execute whatever they want to do. So I want to make that point, Your Honor. Like our suit, our request for injunctive relief and our TRO is based. I know there's a lot being said. It's really based on these two things: the Articles of Incorporation and Mr. Farnsworth also take on the board of directors, taking the ability of the common shareholder who we believe owns a majority of the company, not allowing them the opportunity to select and elect board of directors that serve in their own best interests. So I want to make that point, Your Honor. In closing, I just want to say I believe that the TRO should be granted on the fact of the illegal amending of the Articles of Incorporation as well as the hostile takeover conducted by Mr. Farnsworth that allowed him to execute agreements that harm shareholders that work to his benefit. Thank you.
All right. And Mr. Genis, you didn't feel cut out, did you? You still have a little more time before.
Yeah, I just have like 2 points that I wanted to make. Mr. Vick had addressed that, you know, we have 50 million shares from just the 1,200 people that have signed up for the website that he created, which we do not represent, but which we have this information. 50 million shares at the current extremely depressed stock value of 25 cents, 24 and change, whatever it is at the moment. That works out to $12.5 million. This company has a value of $60 million. So even that 1,200 the 1,200 people, their combined ownership of the company, just that 1,200 people, that shows you how significant the Main Street ownership of this company is. That's the first point. My last point, so I don't repeat anything. When I was earlier addressing the court, I couldn't remember the term of art that I wanted to say. You've heard all this talk about Mr. Farnsworth and how he sets up the deals with the payments and everything. The word that I was looking for, the term of art, is self-dealing. And the problem that we see over and over again with anything that has Mr. Farnsworth's hand in it, and currently it's Vinco, is self-dealing. Self-dealing with respect to Magnify U, self-dealing with respect to the acquisition of Lomotif, self-dealing with respect to the AdRiser acquisition, currently the self-dealing with respect to the acquisition of the Inquirer. It could go on and on and on, but the bottom line is that we have a formula for fraud which involves self-dealing, and we need the court to weigh in with a temporary restraining order, and I just don't see how it would harm anybody if you were to say either, just don't hold the meeting yet, or just, I'm ordering you to have your stock trading halted until we can kind of get through this. Maybe even both of those things, and that's it. Or maybe hold your meeting and hold off on the vote because I have concerns about this preferred share voting issue, and I want to make sure that, you know, that the vote doesn't go through illegally. That's all we're asking. And if I were to say another word, I would be repeating something that Mr. Muntz said, only I wouldn't be as articulate as him. I wouldn't be as concise as him. And if I was to continue, and I would probably repeat something that Mr. Vick said, and I would lack his articulation and his passion. So with that, I submit.
All right.
Your
So-
Honor, may I
Yes,
just
sir.
add one thing I forgot to
Of
mention?
course.
Very important point. We're seeking no compensation. We are not trying to make a dollar. We're just trying to save our company. And that's what I'll end with.
And I am not going to grant the TRO, but I'm going to look you in the eye and explain why. Because I don't think legally I can even do it under Nevada law. You have, assuming everything you've said is true, and I take you at your word, you have a great case for minority suppression. You have a great derivative lawsuit, but it's not the type of relief I can grant to the individual shareholders. The company is required to have an annual meeting by Nevada law. If I circumvent that, I'm going against Nevada law, which isn't correct. You have the ability to recover in an alternate way based upon the minority suppression or derivative, and you can collect money damages. That's a type of loss that company boards of directors insure against. So you may have a remedy there, but it's not individually to stop the annual meeting. I'm concerned about the standing of who you can represent, because yourselves as individual shareholders don't, or your remedy is to elect somebody to the board, or once an act happens, then to challenge it again. And assuming you find good counsel, that they will know exactly, if they read this transcript, they'll know exactly I'm giving them a roadmap. So, so even though, you know, and unfortunately considering the company, they would have irreparable harm if I enjoined the meeting, because then they would likely get delisted. So I just don't believe that it's appropriate for me to stop the annual meeting or stop the election. There's also an issue with what we call ripeness, which I'm not sure the case is ripe at this point, because usually an event has to occur before you can sue on it. So you're trying to keep something occurring, which if it occurs, may give you a better cause of action and a better way to recover. So those are the reasons why that I can't, and I will entertain your questions on both sides if you have any.
Your Honor, I don't have any questions, but I do want to personally thank you for taking the time to read the pleadings, and more importantly, as a practicing lawyer in California for so many years, I understand the mechanics of coming into court and asking to jump the line for a priority setting in every respect, for TRO, for the 10 days and then bumping it up even earlier. And the court has been very accommodating and very understanding and very patient. And I said this morning, I said, I don't know what the outcome is going to be, and we may very well lose, but at least we tried. And we couldn't have tried if this court wouldn't have given us the opportunity to have this hearing today. And from the bottom of my heart, I thank you for that.
I wanted to get this done for everybody. All of you need a peace of mind. And you're welcome, but I did ask for the job, so. Anyway, all right. Did you have any questions, comments?
I do, Your Honor. Also, two things of housekeeping. Also, with regards to the request for the receiver, because they did a separate motion, is that also denied?
Yeah, I'm not going to entertain a motion of a receiver at this point.
And then also, there's still a hearing, even though they moved up, there's still a hearing on April 27th. Is that also vacated?
Oh, I just went dark. Let me go back up.
Sorry about that.
It does it every 10 minutes.
It's a motion for emergency order granting plaintiff's request for TRO. Is that today?
That's today.
Move
Yeah.
it to today, okay.
The hearing
It'll be moved to
that
today.
you set for April 27th will go off calendar.
And
based
Your
on
Honor,
ruling.
I'm sorry,
Let's
do
let
you
her
want to say
finish.
something? 'Cause I wanted to.
Maybe let her finish?
Yeah, of course.
If you'd like, you want me to prepare the order and I can show it to the other side, Your
Yeah,
Honor?
you will have the ability, all three of you, to review and approve the form of a simple order. And you sign it, doesn't mean you agree, just means that you've seen it. And if you don't, I'll wait 3 days, and if the order is appropriate, I will sign the order. Now,
Your Honor, as a matter of housekeeping, I've paid close attention listening to you about what, the proper avenues moving forward would be. I understand the rightness issue on all of that. I understand Ms. Stein's talk about the lack of a summons, all those different things that have occurred. I would propose, and we can talk about this later outside, that from this point, at least, and I would encourage my co-in pro per plaintiffs to join with me to give counsel for the defense an open extension to answer, with the understanding that we're probably going to end up dismissing with prejudice or without prejudice, to keep this to a minimum of how much work is required for the court and certainly for defense counsel.
I don't usually want to hear your strategy in the courtroom.
Okay,
But
I understand.
certainly professional courtesy goes a long way.
Yes, so I just wanted to put that on the table on the record, that I don't want people to be burning up time and valuable money and all of that, and I appreciate judicial economy, and I've taken to heart the path forward that you have suggested, and we'll pursue that.
Thank you. Mr. Lewis, did you have anything to add?
Yes, ma'am. I just had a question with regards to the Articles of Incorporation and just my clarity on the law on that piece. So even if and I'm asking this as somebody who's not an attorney, so please forgive me if this is a bad question. But is that an issue that would need to come from a derivative suit or another type of lawsuit? As a individual, could I file suit if I believe the company is illegally, if they're illegally amending their articles of incorporation?
As a judge, I'm not allowed to practice law. I know the answer. I can't give you that answer because it would be a violation of my oath.
Copy. Okay.
All right? Good enough, everybody. Have a good weekend. Safe travels to all of you.
Thank you, Your Honor. Thank you.
Thank you, Your Honor. Go nice.